السلام عليكم ورحمة الله. أهلا بكم إلى هذه الحلقة من برنامج من الداخل عبر قناة الميادين. معكم زينب الصفار. لعل السياسة الخارجية للولايات المتحدة الأمريكية تخضع مرة أخرى للتدقيق، حيث عملت الإدارات الأمريكية المتعاقبة دائما على حماية مصالحها الإقليمية في منطقة غرب آسيا بتكلفة باهظة تتمثل في تجاوز القانون الدولي. إن ثقافة الإفلات من العقاب والكيل بمكيالين تؤدي في النهاية إلى تآكل الركيزة الأولى والأساسية للقانون الدولي والقانون الإنساني، وتعرض سلامة عالمنا بأكمله للخطر. وبحسب المراقبين والقانونيين فإن الاغتيال غير القانوني لجنرال عسكري عندما لا تكون دولتان في حالة حرب أو حتى نزاع مسلح مباشر لهو يدل بوضوح على عدم مسؤولية الرئيس الأمريكي دونالد ترامب والسلوك المتهور والإهمال الجسيم الذي يسبب تهديدا خطيرا للسلام العالمي. مشاهدينا الكرام، يطيب لنا أن نستقبل من مدينة جوهانسبرغ في جنوب أفريقيا الأستاذ زياد باتيل، المحامي في القانون الدولي والناشط الحقوقي، حيث نستعرض معا مقاربة من منظور القانون الدولي تتعلق بالقتل خارج نطاق القضاء للفريق قاسم سليماني ورفاقه، وأيضا أهمية الدفاع عن القانون وحمايته. Right, from South Africa, Ziad Ibrahim Patel, Johannesburg-based attorney, international human rights lawyer, and lawfare activist. Welcome to Min al-Dakhil from the inside, sir.
Thank you. Assalamu alaikum, Zainab, and a very good afternoon to your viewers. And thank you for having me on your important show.
Thank you. Pure pleasure to have you, Ziad. Well, let's start in the aftermath of a carefully planned and orchestrated drone strike which killed Iran's Major General Qasem Soleimani and Deputy Commander of the Iraqi PMUs, Abu Mahdi al-Muhandis. The question on the lawfulness of the fatal attack by the US in the sovereign territory of Iraq must speak volumes. Did Soleimani's assassination violate international law, Dr. Ziad Patel?
Zainab, that's a question that, has a very straightforward answer, more especially looking at it from an international law perspective. International law would invoke some kind of penalty or imposition whenever there's a situation of, a state country or any of its intelligence or military agencies perpetrating an extrajudicial killing on extraterritorial sovereignty of another state. In this instance, General Soleimani was assassinated on the sovereign territory of Iraq. Most certainly that kind of conduct would be rebuked by the international community, and most certainly, would fall foul of international law. So in this instance, yes, orchestrated plan by the United States, in the assassination of General Soleimani and, the general that was with him or the person that was with him would speak volumes in international law. Most certainly that is the case. So we know that Iraq's Popular Mobilization Force, Abu Mahdi, was one of the victims with General, Qasem Soleimani.
Yes.
Further to that, we could look at, the different kinds of U.S., one has to look at U.S. foreign policy over the many years and the many decades that has, is behind a political campaign and a mobilized campaign. And in this instance, we know about the neo-conservatives, the neocons, that utilize international interventionism as a mechanism for furthering their foreign policy. And in this instance, that foreign policy is advanced, on countries like Iraq, Iran,
Syria,
and
Iran,
Syria,
yes.
and all those countries that are contiguous to each other, in part of the greater balkanization of the larger Middle Eastern states. From an international law perspective, we've got to continue criticizing and being critical of the United States in its actions against, this assassination. I would like to state, a professor in my article that was recently written, Sir Mary Ellen O'Connell, law professor and an expert in international disputes at the University of Notre Dame, where she correctly rebuts, we have carried out the attack on the territory of a state that plainly did not give us permission. The attack was unlawful. The assassination was not justifiable. And I think that would be the interpretation of the assassination, of General Soleimani in terms of international law.
Mr. Patel, that said, there are also U.S. presumptions that Soleimani was planning an imminent attack on U.S. facilities and workers in Iraq, in Lebanon, and in Syria that would have killed hundreds of Americans. Were the allegations against Soleimani ever tested in a court of law at the ICC, International Criminal Court, or at any other properly constituted war tribunal? Before being targeted, why was Soleimani not afforded, and here we are talking international law, why wasn't he afforded an opportunity to rebut these allegations?
Absolutely, Zeynep. 100% with you on this, that there needs to be a due process to be followed. You can't simply take, a general of a country such as Iran and target this particular person because he proposes to be an imminent threat to either the American people or to American military or so forth, without any form of investigation, without any form of due process, and also bringing General Soleimani to a proper court or tribunal. There are different mechanisms that would be available under international law. Of course, the diplomatic, the diplomatic avenue had to first be exhausted. In this instance, if that diplomatic avenue was not exhausted, there could be an approach through the United Nations. There could be a request at the UN Security Council, the United Nations Security Council, for the establishment of a special war tribunal. We must remember the fundamental principle in law is the audi alterum partem, which means that you must give the opportunity to the other party to be heard.
To listen to the other, true.
Yes, to listen to the other. And none of this was ever afforded to General Soleimani. The Iranian government was not involved in any form of discussion or negotiation to say that, look, General Soleimani is, operating outside of the ambit of the instructions of his state and is committing some kind of private activities or military activities that's causing issue with, U.S. forces and so forth. We understand that there's a difficult, situation permeating in the Middle East at the moment, and United States forces are based in Iraq, and we understand the issues, the geopolitical dynamics at the moment that exist, which creates that kind of difficulty. But that does not give any legal justification to any state to try and, to conduct the kind of activity that was done by the U.S. president. And, just having a look at some writings on this, I picked up, an important piece, an article that's, directed to a certain point that, President Trump first perpetrated the act of assassination and then tried to rectify it in international law to say that, there was, in subsequent tweets,
threat.
Yes, that he was an imminent threat.
Yes.
But that imminent threat was not tested in any court of law, tribunal, or forum. And the imminent threat issue was only raised after the assassination.
On this particular issue, Mr. Patel, on this particular issue, Article 51 of the Charter of the United Nations prohibits the use of force except under two circumstances: when the use of force was authorized by the UN Security Council and when a country acted in self-defense. self-defense. Now, self-defense when an attack has not yet occurred but is anticipated is called anticipatory self-defense. Anticipatory self-defense should be distinguished from preventive or preemptive self-defense, which seeks to halt a future threat, often in the absence of precise information. As a doctrine in international law also, anticipatory self-defense is still in flux, in continuous change. My question, Ziad, does the legality of an attack depend on the immediacy of the threat that it aims to avert?
So anticipatory self-defense is what you're speaking about, is also known in common law as self-defense or private defense. There always needs to be that kind of proportionality involved in repelling that attack. If that kind of attack is anticipated and imminent. Certainly in this instance in international law, applying the principles of international law to the manner that General Sulaimani was assassinated, clearly there was not any form of cooperation between the US government and Iran. There was no indication or evidence that the international community was involved over a period of time that General Sulaimani was planning these kind of attacks and so forth. It seems to be military intelligence, and this general sense of impunity with which the United States and Israel, perpetrate crimes with impunity. Without any form of due process. I think international law experts would be of the same opinion, and as I've just mentioned earlier, that they would be of the same opinion that this kind of imminency or anticipatory self-defense, certain factors and requirements need to be met.
Right.
In this instance, the US president hasn't, met those requirements or standards.
Excellent. Ziad, allow us to stop now for a short break, and then afterwards we will continue to focus more on this international law approach, but after the break. إذن فاصل قصير ونعود. لا تذهبوا بعيدا. From South Africa, Ziad Ibrahim Patel, Johannesburg-based attorney and international human rights lawyer. Welcome back, Ziad. Well, the actions of the U.S. set a dangerous precedent whereby states like the U.S. and Israel, as you said before the break, encroach relentlessly international law with impunity. So, if other states also promise retribution, vengeance, vendetta, they can do that based on an aggression on its soil, like what happened with Iraq, for example, and citizens, or even just for deterrence. What do you say on this, Ziad?
Yes, this is exactly what the concern is of international law experts. I think the perspective of us trying to create a better world means that we all need to become in compliance with rules, regulations, norms and standards, Zeynep. We must understand that the United Nations was formed post-World War II as a result of the huge atrocities and that emanated from World War II. We know of the Holocaust and so forth. And humanity wanted to move in a positive direction. This gave the birth to the United Nations in the 1940s, post-World War II. What subsequently has happened to that is we're seeing more and more countries, the United States, Israel, Saudi Arabia, and other states, every day violating these norms, these standards that we have in international law. If nobody then complies with these standards and complies with due process, eventually what happens is the substratum of international law diminishes and we have some kind of pariah systems coming into play, which has no accountability whatsoever. Mm-hmm. And this is the fear, because when there's this culture of unaccountability, we then eventually lose the prescripts of international law and what it's aimed at doing and enforcing and controlling.
In the sense, Ziad, do you still believe in the sacrosanct prescripts of international law and that they can be truly implemented regardless of the power of the wrongdoer or the criminal who perpetrates violence with utter impunity?
Yes, I mean, we have to judge this kind of impunity to something or to some standard. In the absence of international law, how would we be able to, judge these kinds of crimes perpetrated with impunity? This is an important question that you pose to me because, we see these difficulties, this intractability within the United Nations, parties not subscribing to, the Geneva Conventions and to the International Criminal Court Act. So one of the avenues that I advocate for is the strengthening of domestic laws. And so if countries or states ratify their own statute, what they can do is they can also build within their countries and domestic juridical systems, judicial systems, the kind of enforcement mechanisms. So in South Africa, what I've done is, we drafted the first IPSRA bill, which is the Implementation and Protection of Palestinian Solidarity Rights. This is an important piece of legislation because we know of the culture of impunity. We know that Israel is being, difficulty of being held accountable under international law in the ICC. And if we can try and duplicate this kind of domestic legislation into other jurisdictions, what happens is we can have this principle of complementarity come through, whereby we can say that we're not only going to be holding these perpetrators accountable in international forums, and if those forums are intractable, then we can certainly do that within domestic jurisdictions. And this is where advocacy campaigns are important, legal people, jurists and so forth, that must come around these kind of initiatives like IPSRA to come and say that, look, we want to lobby our governments and politicians to have this kind of legislation put in place. Because after all, Zeynep, we want to create a better world. We want to create a fairer world, and we want to give some kind of legacy intergenerationally to our children.
Excellent. So, in this sense, Mr. Patel, the Palestine Solidarity Alliance condemned in a statement the ill-devised Middle East plan coined as the deal of the century, arguing that the plan contravenes international law, including important UN resolutions. As an expert in international law, how does it flout both international law and UN resolutions?
It flouts it. I mean, it's very clear. The deal of the century is in contravention of the UN Security Council Resolution 2334, which specifically speaks about, the non-expansion of settlements in the Middle East. We know, the Syrian Golan Heights has to be regulated under certain prescribes, which is not being done. So the deal of the century must be rebuked. It's basically Trump's attempt outside of the prescripts, outside of what the international community wants, when it comes to the Golan Heights, when it comes to the non-alteration status of Jerusalem. Very clearly, Jerusalem, the situation with Jerusalem is that it needs to be properly negotiated between the parties. It sort of has a international quasi-status. Israel cannot take ownership of Jerusalem. Jerusalem is not to be given by the American government. There's no right, there's no basis for that. And of course, I mean, there's questions about the right of return, the aspirations of the Palestinian people that need to be considered in the way that there would be resolution on this Palestinian, on the Palestinian issue. So clearly, again, the deal of the century is an ill-devised plan by the United States in terms of their foreign policy to take control of important resources in terms of their policies. Yes.
Sure, and also it's in the sense it's very ironic that Trump's son-in-law Kushner proclaims, quote, if the Palestinians reject this generous offer, they show they are the spoilers, unfit to have a state of their own, whereas, and you as a South African expert in international law, and you know the suffering of the Palestinians more than others because you've been there, the words of the legend Nelson Mandela must resonate during these precarious times for Palestinians living under belligerent Israeli occupation. Quote, we know too well that our freedom is incomplete without the freedom of the Palestinians, the words of the iconic Nelson Mandela. Allow me to ask you my last question, Ziad, today. And we cannot but turn an eye to this particular important issue. Now, when the world is appalled and taken by the rapid spread of coronavirus, not so much focus or attention is dedicated to highlight the plight of Muslims in India, the horrendous and racist atrocities committed against its Muslim citizens, also in direct brazen breach of the human code, rights, values, and law. What can you tell us about that, Ziad?
Yes, it's a very, very tragic situation that is unfolding in India, and we're seeing this nexus plan between, India's Prime Minister Modi, Benjamin Netanyahu, President Trump, all siding together with certain right-wing fascist ideological agendas. Like we would condemn Zionism, we'd also condemn the right-wing, Hindutva, as it's called, that we must be able to separate Hinduism from this right-wing political ideology. Modi's party is accompanied by this organization called the RSS, which is very similar to
extremist right-wingers, yes.
Extremist right-wingers. In fact, just after India gained its independence in the 40s, they were in fact responsible for the assassination of Mahatma Gandhi.
Sure.
And they were isolated and banned from India because they were a blemish to the fair name of India, as it was said. Unfortunately, they've now come into power, and we're seeing this Islamophobic attempts, this pogrom against Muslims. It's nothing less than ethnic cleansing, and this kind of ethnic cleansing can then lead, to genocide. I think Muslims in India, not only Muslims, all Indians that believe in a constitutional system, in democracy, in upholding of human rights, would disagree with the Citizenship Amendment Act, which proclaims to give certain rights to certain religious groupings, excluding Muslims from Afghanistan, Pakistan, and I think one more state, Bangladesh. Now, if that is the case, what you're doing is you're moving from a constitutional secular state to religious ideology. You bring in that kind of ideology into your governance structure, and that is extremely dangerous. So I think the Muslims in India have a legitimate right and aspiration to live freely, a state of democracy, and not to have their rights violated. They are being severely oppressed.
Of course, this is their ultimate right, of course. Right. From South Africa, Ziad Ibrahim Patel, a Johannesburg-based attorney and international human rights lawyer and lawfare activist. Thank you very much, sir, for your insights.
Thank you, Zainab.
Always welcome, sir. Always great to have you. والشكر لكم مشاهدينا الكرام على طيب المتابعة. للمزيد من التواصل تابعونا على صفحات السوشيال ميديا من كل فريق عمل برنامج من كل الميادين. السلام عليكم ورحمة الله.